So often during consultation, people say to me, they don't understand. One day the sheriff just rocked up at their house, repossessed their vehicle, but they've never heard of this process or anybody interested in legal action against them. So today I'll explain to you how the legal action process works, which creditors need to follow in order to obtain a judgment against you. So what happens? You'll start skipping payments. Month 1, nothing. Month 2, creditors might start phoning. After month 3, usually the creditors will issue a final demand or Section 129 notice. Section 129 notice is served by a registered mail, except if you consented to any other form of service at the time of entering into the agreement with the credit provider, but usually it will be served via registered mail. You get a slip in the mail, go fetch the letter at the post office, which will say, in terms of Section 129 of the National Credit Act, you are now in default of this credit agreement, which means that you've got 10 business days to either settle the arrears, dispute that the amount is owed, or consult with the debt counselor. So 9 out of 10 times we ignore that notice. After 10 business days, the creditors will proceed to issue a summons against you. Now, during the summons stage, you have one of two options. You can either defend the summons, no, don't know about this debt, or no, I've actually paid you, this debt is not due, or you can consent to judgment. So, should you ignore the summons as well, which is normally a big stack of documents which is delivered to your domicilium address, the creditors will apply after 10 business days to obtain a judgment against you. Should the judgment be granted, they can apply for delivery, which means in terms of a vehicle agreement, the sheriff will come and collect the vehicle. They can attach your assets, also a garnish order on your salary, or a warrant of execution in terms of property, which means that they will then collect the property, sell it on auction, and then if there's a shortfall, you will still be liable for that shortfall as well. So very important is, once you receive a Section 129 notice, do not ignore any of these processes. Contact the credit provider. Should you be in default, enter into an arrangement with them. If you cannot enter into an arrangement at the Section 129 stage, contact the debt counselor to enter into these arrangements on your behalf by means of a debt review process, which means that the credit providers cannot proceed with the legal action and eventually attach your property. The debt review process will then secure your assets against repossession and afford you the opportunity to repay this debt at an affordable installment and reduce interest rates.